Yes, the questions people left me in my DMs. So the first question I got was, how much does it cost to do a divorce in Kenya? And mostly it's around 100K. If you ask around other law firms, you'll probably be given that amount. You know, the thing about law is that we have something called an ARO, which is the Advocates Remuneration Order. So we can't charge below a certain number or else we'll be in trouble. So we have to charge, there's a cap, you can't undercharge, that's an offense for us. So it's around 100K. Have that kind of money. If you don't have that kind of money, you can organize with your lawyer. You pay a deposit and then you do it in installments. And then somebody else asked, how much is a consultation? Consultations depends on the law firm, but as we do it for 5K, depends on the law firm. So if you want a consultation, there's a link in the description. It's not 5K because that app only uses USD, so it's about 35 USD, but it's around 5K. If you walking into a law firm, you'll probably be told that amount, but depends on your lawyer and how they charge in that law firm. And then the third question is, now we're going into custody. The mother was given custody but has no interest in the kids. So this person was asking what to do if one parent is given custody but they seem to have no interest. One thing you learn about law is that you need evidence in every single thing. So if you're saying she has no interest, you need to start collecting evidence to prove to the court that she has no interest so that you can make an application to edit or amend the custody order. So for example, we had a client who was like, gave up custody of the child and was like, this other parent isn't shughuliking the child, like the child is with the grandparents and the child isn't doing, the parent isn't doing much for that child. So what she did, she collected evidence. The child had like some infections on the skin because of neglect. So that was evidence. That report was used as evidence. So you can't just yap. You know, when you talk to the court and there's no evidence, it's like you're yapping, because the other side will also come and yap and say like, what do you know? You have no evidence. You're just claiming things. So every time you need the court to do something for you, please provide evidence. So if you say that the mother is not interested, bring evidence, bring texts, bring medical reports, anything that will show that this parent isn't doing what they should with the child. Okay, let me see if there are any questions. No questions. Okay, let's move on to the next question. Oh, and then this next question was, the parent had been denied opportunity to see the kid, right? And so what should they do? Now, each parent has equal parental responsibility and equal access to the kid unless otherwise. So this is a very simple case. You can just make an application to the court in custody and maintenance matters, right? So if you're truly being denied access, you need evidence. Again, you need to show that you've been texting this person, you've been writing to them, hey, can I see my children? Can we arrange a meeting? And then they've not been allowing you. The best way is to text. We need evidence when you're making your case. So you say that she's not been giving you access or he's not been giving you access. Bring evidence, even if WhatsApp is still evidence. WhatsApp screenshots are taken as evidence. Emails are taken as evidence. Anything you can bring to show that they're not allowing you access because you have that right as a parent. And also, here's the thing, this is what we tell our clients. Okay, you need to position yourself in law. You need to have a strategy. You can't just say things. So courts have been seen to be very understanding of parents who really, truly have shown that they have the best interest of the child. If the parent is showing that I've been paying the NHIF of the child, I've been paying their school fees, I've been doing everything for this child, you can see that I'm a responsible parent. The court does not, the court sees your effort. So if this person is denying you the right, you can just go to court, make an application under agency and say that this person is denying me my rights, and this is what I've been doing. I'm a responsible parent, and this is the evidence. So evidence rules all, okay? So you can make an application to have her allow you to see the children. Oh, here's another thing. If you don't necessarily have the money, let's say for starting a case, What you can do is, if you earn below 30,000 shillings, there's the National Legal Service. They offer free legal services for people who earn below 30,000. So what you do is you show your, what do you call it? You show proof of earning. So if you can show that you're not employed or you don't have any source of income, then it's very easy for you to get free legal aid from them. Another thing is you can go to children's offices, and even if you don't get the help you need, as long as it's in writing, you've written a letter and you're showing that you've been trying to get this custody and maintenance, this will build up your case. A case isn't just, oh, today wake up, and you have to think about a lot of things. That's why we have consultations, and we'll ask you questions like, how old are the children? Have you been living with the children? Have you tried anything? Because the court wants to see your effort. So if you show that you've gone to the children's offices, you've sent messages, the chief called them, you have evidence of that, you have it in writing, make sure you ask for copies of all those documents, then you'll be building up your case. Hello guys, the ones who have joined. If you have any questions, you can leave them in the comments. I'm still trying to figure out this. This thing. Okay. Okay. And the next question. So this question was from somebody, and they said that the mother had run away with the kid who was below 1 year. So this is a month-old child. And the kid got sick, right? And this lady has 2 other kids who are not his. So he's wondering how he can get the kid, because he's the one who's been taking care of the kid's medical expenses and things. Whenever she runs away with the kid gets sick. So here's what you can do. Remember what I told you guys? If there's one thing you can remember from this life, it's evidence. You have the right as a parent. Both parents have equal responsibility and equal rights to this kid, right? So you've said you've been paying for the medical expenses of the child. Have those records. Never throw away those receipts. Have those records. After you have those records of, the medical care, you're gonna also use those reports as evidence of this person's neglect of this child. So what you can do is make an application to court very quickly. Somebody like that has a strong case because you can show that you've been taking care of the child, and this person's actions have continually led this child to danger, like physical danger, and you have those reports from the doctor that every time she's run away with the kid is sick. And then even if the court sends a children's officer to do a home visit and can see that this child is neglected and this person has other children and this person is in the tendency of like running away with the children, then you have a strong case. Honestly, you have a strong case. So what you do is make an application. Go fast. This is another thing. I made a video yesterday. The law favors the speedy. Run quickly. Go to the children's office if you don't want to go to a lawyer. Go to a lawyer right now. We'll write a demand letter. We'll do whatever you need to do to get that person, to get the evidence we need and to get that application. The applications you can do under urgency. If there's the child is in danger, you can write to the court so that the matter is fast-tracked. Like within a day, there are orders within that matter. For example, the child's life is in danger, things like that. You go under urgency, quickly file that application and have that child removed and brought to your custody. And then this question I really hesitated to answer because it's deeper than just custody and maintenance. So this person said that her husband doesn't do anything and he gets violent when she asks for maintenance and for him to do something. I don't know what co-hosting is, but I'll figure it out later. So now, what was I saying? So here's what you do, okay? Such a person needs to really, really figure out their priorities, okay? Because this is criminal, right? This is a criminal offense for somebody to be violent towards you. What I would advise is, if it was me, I'd be planning my exit. I'd make sure my finances are in order. I would figure out, because if he's not paying for anything anyway, that means you're responsible for everything already. So that means you can do the stuff on your own. So what you're going to need to do is collect evidence. Number one. If this person is violent, okay, you can either report him, but if you see as if reporting will not do anything, you can get reports like of the physical altercation that has happened and get a report, and you're going to use it, okay? Oh, I see another question here. Okay, you're going to use that as evidence. Remember, guys, receipts speak all. They'll speed up your case. They'll make your case very obvious to the court, and they'll make judgment in favor of you very easy than if you are just using word of mouth evidence. So you're going to collect as much evidence as you can, and you're going to plan your exit. That's the best I can tell you to do. There are so many institutions that help people who are in such a situation, so you can search them up. And also the National Legal Service, again, they do free legal services for people who earn less than 30,000. So you can consult with them. They'll give you such good advice. Okay, collect that evidence, get the doctor's report, go to the clinic every single time, get those reports. Here somebody's asked, can one claim adverse possession if they were given land of a deceased person by one beneficiary? Adverse possession is something that happens when you've been living on a certain land unchallenged for 12 years. That means that person saw you settle down there. They've seen you farm. They've seen you live there. They greeted you as neighbors. They were like, oh, welcome. They literally saw you there, and they never challenged, never sent a letter, never did any case, allowed you to stay on the land for 12 years, 12 good years, uninterrupted. So it's not like I stayed for 2 years, and on the third year, they tried to kick us out. And number two, I've never paid them rent or anything like that. So you are basically a squatter, and you are allowed to stay there. So you cannot claim adverse possession unless you've been staying on a piece of land for 12 years, unimpeded, unchallenged. If you're given land by a deceased person, the land by one day, I need to understand the situation more, because I don't understand how you were given the land. Was the land transferred? Did they say this is your land now? But adverse possession you've had. You just need to be staying on that land 12 years unchallenged, and then you make an application to court. If it is the land of a deceased person, it's not possible. I don't think it's possible to do adverse possession, because you remember we said the land is part of the estate of the deceased, and of course somebody will challenge you. So if they've not done succession for 12 years, trust you, there will be somebody who will say, no, this was challenged, this is a squatter, this is part of the estate, these are intermeddlers, it's very complex, it's very complicated. Okay. Okay, so here's another question somebody sent in my DMs. They bought land and they have a sale agreement, okay, but the land was bought before succession was done, and then there's a main beneficiary. There's a main beneficiary who is the son, and he's not done succession. So this person and the family fears that this son will sell that property without their consent, and therefore the family members are not allowing him to do succession. Let me tell you, this question is a bit complex and convoluted, but I'll try to explain it the best that I can. Number one, buying land where succession has not been done is the riskiest thing you can do for yourself. You've said that the son is a beneficiary, okay? Number one, who did you buy this land from? Was it the son, or was it another beneficiary? And is this person even a beneficiary? Because remember we said not all family members will count as beneficiaries. If it's the brother of the deceased, that person is not a beneficiary unless this deceased person didn't have a wife, didn't have any children, didn't have anything. So the fact that somebody like a brother can try and sell you land, you can lose, let me tell you, you can lose so much. We've seen our clients pay money, and it's been over 10 years and they didn't get the property. So the best they can do is get their money back because they had a sale of land agreement, right? So what you can do is, this person would need a strategy. You need to consult with like a lawyer. We need to go through all the sequence of events, the people involved, who sold you that land. Is this person actually a beneficiary of the estate? Because even though the transaction itself is not enforceable, if it was, let's say, a direct beneficiary like this son who they're fighting, then it would be easier to get your land, in that you could get it through this beneficiary. Once they are given the property, you could now get the property from him, right? But now if it's somebody who's not even entitled to the estate has sold you something, that's crazy. And then second of all, they are stopping him from doing succession. How is it? Maybe he doesn't know about succession, but you can't stop somebody from starting a succession if they want to start a succession, okay? And if you do any foul play, other people will come up and it will be a whole tangled up mess. So this person would need really to talk to them personally and consult with them. But if you want consultation and you're serious about consultation, there's a link in my bio where we do consultations. So yeah, number one, I said buying land from a succession that has not been done, from a person who's not done succession is a huge risk because that land is in there. We read a judgment yesterday. It was like from a whole 40-year-old case. Can you imagine? The deceased passed away in 1982. They have over 200 descendants, okay? And they're still arguing over succession. And the purchasers are like, when are we ever getting our land? And you know what the judge said? They said, who did you buy land from? This person was deceased. Who did you buy land from? The best they could do, the judge could do, was give them status quo, meaning nothing to change while you guys run quickly to the Environment and Land Court and see whether you can get your land from these beneficiaries. And how long has it been? It's been over 40 years. Seriously, it's not worth it. And let me see if there are any questions. Okay. So, which other question is this? Okay, so the deceased father, this person asked, the deceased father had 4 brothers, and the oldest one sold the land without consent. Okay, so when I read this question, I think what came up was ancestral land. And then here's another thing. If you're sending questions, please be very direct. Like, even if you give me like a background, then ask the question directly, okay? So here's the thing with ancestral land. It's also a headache. It's also a headache. Like, majority of our succession cases which have problems are ancestral land, okay? I don't know why. So here's the thing, okay? Whose name was on the title? That's where we need to start. Whose name was on the title? You say, oh, it was the brother holding the land in trust for the others. Do you have evidence? Are there witnesses? Can you really prove what you're saying? And know this, that a title is, at face value, evidence of ownership. Prima facie evidence means like in the face of it. When somebody produces a title, we stop thinking there. We're like, okay, that's the owner. That's the owner. So you are the one who has to come and prove that there was some foul play getting this title. So we've seen a lot of people lose land because one family member who was the head of the alleged ancestral title, but his name was on the title, went and sold the property. And then these other family members are like, what do we do? You know, like, he's already sold the title. He's already sold the property and the title was in his name. Now they're trying to prove that it was ancestral land. And by that time, things have moved, things have changed. Like, it's crazy. So with ancestral land, you need to be very careful. Title documents are important, witness testimonies, and real proof that it's ancestral land. And let me tell you, changing ancestral land to be private land, that is a whole other conveyancing hill that you'll need to climb. It's not as obvious as you're just selling one private property to another person's private property. It's complicated, okay? It's complicated. So yes, if you see ancestral land, this is just caution to all land buyers. If you see no titles have come out, run away. If you see it's succession and it's allegedly ancestral land, headaches. You'll need to go to a lawyer. We craft for you a strategy, okay? A lot of you guys come to lawyers when your house is already burning and things are already a mess. It's best to go to a lawyer quickly when the petrol is still being poured, so that we can stop that person. The law favors speed, right? I told you yesterday there's something called the Limitation of Actions Act. So if there's a matter and you're sitting on it, you might be closing the door on your own justice because you didn't go fast enough. Because there are so many cases in court. The court doesn't have time for people who are sleeping on their rights. And the first way we usually throw out cases very easily is to say that the person is out of time. The person came late. What are they doing here anyway, right? Okay, so this next question is an employment question. So this person signed an employment contract for 3 years and it's over. They were told to write a resignation letter but didn't. What to do? Number one, I'd have to see the contract. Every single contract has its terms and we usually follow contract. And then matters of contract, by the way, from the date of that alleged breach of contract, you only have 3 years to file a case. 3 years, okay? So I hope the case wasn't something like in 2020. That one, you've already started making your case weaker and weaker and weaker and harder for us to defend you. So the thing is this, I'll have to see the terms of the contract. Did it have anything to, did they do your severance pay, things like that? Were those things listed? What were the termination terms of the contract, okay? You didn't write a resignation letter. That's not really material. I'd have to see the contract. That's the thing. I've read some contracts and I'm like, did you sign this? The other day I dealt with a very, very unfair contract. It was so sad. They made sure this person was on probation. Okay? So being on probation means that you only have 6 months, right, on probation before you become a full-time employee. If you're on probation, it means that you're on a probationary contract, and it means that you can't go under unfair termination of employment. Do you know how serious that is? That means that where most employees, when they are fired or when the employer does something really outrageous and you have to quit your job, then you can go to court under unfair termination and say, hey, they fired me unfairly, I need 6 months pay. There's a whole package of things you ask for when you've been terminated unfairly. But a probationary contract, you can't. The best you can do is get your pay in lieu of notice, which is only 7 days compared to a full contract. And that's it, right? So that's the thing about probationary contracts. You have to be really careful. And if you quit your job before your probation is over, that's even worse, right? Because even that payment in lieu of notice probably won't be there because you quit before the time was over. Please wait until your probation is over, please. It's better to do things when you're a permanent employee. And if they do fire you before your probation is over, you can get your pay in lieu of notice, okay? That's what you can do. So yeah, I'd have to read the termination clauses of the contract. Okay, so the next question is, this person is a firstborn and his parents are separated and the dad remarried. Okay, so parents separated and the dad has married somebody else. And he feels that the father might disinherit them because these kids went to live with their mother. So when the parents separated, they went to live with the mother. And then, but the father now is close to his current family, his wife and kids. Number one, this person is still alive. Let me tell you, there's this funny case that happened. The courts were even talking about it. You can't do succession when somebody is alive. That person is alive. And somebody's property during their lifetime is not the subject of succession. In fact, when we are doing one-on-one consultation with some of our clients and they are trying to see how they can manage their estate, because how succession laws in Kenya sometimes work is that you can't disinherit children or beneficiaries, especially if you do without a will, right? So the thing is, if this person doesn't want a certain property to go into someone's name, there are other ways you can go about it during your lifetime, right? You can transfer your property to whoever you want during your lifetime. Doesn't matter. It's my property. I can do whatever I want with it, right? So this person is still alive. You really can't force them to do anything for you, right? You're an adult. The property that person has in their name is theirs. Now, if the property was joint with your mother, that's a completely different story. The second thing is now, as for now, if this person was deceased, because if they're alive, just forget about it. It has nothing to do with you. If this person is deceased and they had another family, and you guys are here, right? So you're all children of the deceased. All children have equal rights to the property, male or female. All children, whether they are children born outside the marriage, born blah, 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 all children, as long as you can prove that you are related to this person biologically, you have a right to that estate, okay? You're a beneficiary. All children. That is Article 53 of the Constitution, okay? All children, okay? That's not an argument. Have right to the estate of the deceased. Deceased, they need to be dead. Please, if somebody is alive, achana, yeah, that is his property. He can do whatever he wants, give it to whoever he wants, okay? You can you can have a consultation, we can consult in other things, but not that, right? So all children have rights to property of the deceased. Now, here's where it gets complex, okay? Wives. This has been an argument since the age of time. If they were married, okay, by customary law, all of the wives, okay, all, then they will be wives for the purposes of succession, right? The first wife, second wife, third. We've done all those wives, okay? Those ones will be wives for the purposes of succession, and beneficiaries, and their kids will be beneficiaries. Here's number 2. If this person was married by Christian or any other religious, any other religion that requires one wife, okay? And for Muslims, it's 4 wives, but they go through like the Qadis, right? They have like, succession goes through the Qadi, and their law is a little bit different. But anyway, if you're Christian, Hindu, which other religion, whatever, those are the religions that require only one wife, right? And then this person got married by an African customary. These African customary wives might be disinherited. We've done a case like that. It is so scary out there, guys. Because listen, if the Christian marriage says you have one wife and that wife has a marriage certificate, even if she disappeared to whichever country and this person dies, she can come back as long as there was no divorce. She can come back and she will be the legal wife. And we have a case like this where this legal wife had even run away. She got married to someone else, but that old marriage certificate existed. Do you know this lady came back and did succession so fast, sold the stuff, and left this lady who was now the wife married by African customary. She left her with like very few things, only for her children, because her children are dependent, but her herself was disinherited. So you guys better get serious about whatever relationships you're in, because again, relationship doesn't mean rights in court. She had the marriage certificate and it said only one wife. But if you're African customary, everybody's a wife, it's okay. And then let's see the next question. What is the process of changing a 2-year-old baby's name? Somebody asked this. This is one of the questions that says speed is everything. Within 2 years of registration of birth, you can change the name of that child. Just make an application on eCitizen, okay? Within 2 years. So the baby is 2 years. Run quickly before the child turns 3. Like, you guys need to be quick on your feet, okay? Because after that, after those 2 years, the only way you can change a child's name or even your own name is by a deed poll. And a deed poll is a document where you will, you will claim your new name, you will disown your old name, it needs to be gazetted, you need to file affidavits. It's a longer legal process and more costly than if you had just done it within the 2 years, okay? That's number 1. Number 2 of this question was, oh yeah, let me tell you the documents you need. You need ID cards when you're doing that application to change the name of the child. ID cards for the adult applicants, and the child's birth certificate, clinic card, antenatal card, all that stuff. And now listen. Now here's the problem. There are 2 parents when a child is born, okay? 2 parents. So this person is asking, can you remove the father's name from the birth certificate? Yes, with a court order. The law actually protects both parents, okay? You can't just wake up one day and remove somebody's name from the birth certificate of the child. If you did put one when the child was born, okay. But if the name was already there, now you want to remove, Only the court can do that by a court order. And number one, you have to prove that the reason you want to remove the father's name from the birth certificate is because that father is not the biological father of this child. If the father is the biological father of this child, trust me, you're not going to do that. You're not going to remove that father from the birth certificate unless they have consented. You've gone to court, you've got this person and he's like, yes, I agree, please remove my name. I no longer want to be responsible for this child. This mother doesn't want me to be responsible for this child. Please remove it. You see, it's a whole complex thing. You need consent. Both sides made this child, and the law treats both parents as having equal responsibility and equal, access, whatever, to the child, right? So to remove a father's name, number one, that father needs to not be the biological child. So you need to bring DNA report from a recognized institution when you're making that application. DNA, okay? So you have really strong proof of non-paternity. And then you need to do any evidence on the birth certificate. Maybe it was a fraud or error, or like somebody happened to put the name there, but it wasn't his. You need to bring evidence of all that. So, but a joint application with both the father and the mother, you can remove that name. And the legal implication will be like, you don't want this person to like be responsible for this child at all. All right. So that's what you do with removing the name from the birth certificate. If it's just a small error, within 2 years, go change it quickly like this. Stop, no wasting time. Otherwise, things are going to get more complex. Does anyone have a question about that? I've just been talking. Any questions, you can put them on the chat while I answer the other questions. Okay. So here's a question. Okay, these people, they live on a piece of land that their deceased grandfather left. Okay, that's point number one. A land where the deceased grandfather left it, and it was shared between their grandfather and another old man who is also deceased. Before we even continue, was there an agreement? You said the land was shared between these two. Any words without evidence to prove is yapping. That's what the court will be hearing. They'll be like, we can't hear you. So you need a bit of evidence, or else the case is going to be this difficult. You need like so many witnesses to prove it, right? So it was shared between him and another old man who is also deceased. But the land was in the name of that old man. Here's another thing I want to talk about. If you're buying land, okay, and the title, the person selling you the land is not the person on the title, that's a huge red flag. Don't do it. We have a case like that. It's so headache inducing, okay? Don't buy land from people who are not the owners of that land. Anyway, so the other old man has his name on the title, which is honestly making the case weaker. Unless you have like really solid proof of foul play. We did a case where this person did some real, they were real Kenyan. They had a green, what do you call that book called? You know when you get a green card? There were two separate green cards. Yani they had opened another registration book in the lands office, and it was really crazy. So that one, obviously, you can prove foul play, okay? So he says that this land was supposed to be ancestral land, and the son of that old man is encroaching, saying they are squatters. What can you do? If I was you, I would go to an advocate quick. You need a strategy. If I was your advocate, we would sit down and we would talk, and I would be like, okay, how long have you been on the land? Can we possibly explore adverse possession because you've been on the land for more than 12 years. Another thing is, strategy-wise, not everybody is aware of how the law works. So we'll try to settle this out of court. We'll try and settle it out of court. If you can get this person to sign an agreement and agree to the fact that this land was ancestral and whatever other claims you have, then maybe we could have a way forward outside court. But if this thing goes to court, your case is pretty weak. pretty weak. So what you can do is either claim adverse possession or settle this thing out of court and like get that guy and like have a discussion and, you know, settle things, you know, because if you have evidence, maybe, you know, not everybody knows the law. That's all I can tell you. You need to see a lawyer and we need to draft for you a strategy. We need to do like a serious strategy. So yeah. And the next one is his father. This person's father passed away in 2021 and his brother, so I'm guessing the uncle, sold that land without consent. Is it possible to get it back? 100%. If the land was in your father's name, it's 100% possible to get it back. There's some documents. Number one, go do a search quickly on that property. Do a search. Number two, get the green card. Okay. If this land was transferred without succession being done, that was an illegal transfer. We can get that land back, and you need to run to court. Okay. Listen, if somebody does something illegal, if that land was in the name of your father and succession was not done, and your uncle intermeddled, he can even go to jail. That is serious. It's a serious offense. So if a certain property that you live on or that belong to a deceased person is being transferred, you can stop that immediately, but only if you act on your rights quickly. Remember, if you sell, dispose, rent a property of a deceased without doing succession, that counts as intermeddling, and that person can be arrested. And you can go to court and do an application quickly to stop any activity from being done on that land without succession being done. If the land was sold, you can get it back. The person who sold is the one who took the biggest risk of buying a property which succession has not been done. And the next question is, okay, someone said, someone has forcefully taken his plot. What can you do? Such a thing, I'd need to do a consultation, but the consultation link is in the bio. But here's the thing, we need to know if the plot was in your name, whose name was it on, and then go from there. If they are really trying to kick you out of your own plot, we'd go quickly to court and an agency, have that case be listened to quickly, because this is serious, you know, it has very serious complications. I mean, if they sell that land without your consent, like how can they do that? That is illegal. So we'd go to court. That one we can deal with. And then here is a widow and wants her husband's property to be in the daughter's name. That's actually very simple. That's very direct. You just do succession. So when you do succession, you'll just name you and your children as beneficiaries. And when you're dividing the property, you will give the kids the property you want them to have. End of story. That is very simple. We've done it. There's another widow who came to us, did the same thing. You just put your kids as the beneficiaries. It's easier if the person only had one wife. And then, okay, here's another thing. The next question. Somebody has a debt of 5K, their debt, and it's almost been 2 years. Why are you sleeping on your rights? Why are you sleeping on your rights? Because, guys, remember what I said. It'll reach a point you can't go to court. It'll reach a point because you've been sitting on your rights. What you can do is go to the small claims. Okay, small claims court is a court where they wanted to have, like, people have access to the court. It's not very technical. There are forms you can fill and file. It's only 200 bob to file a case. Like, literally, it's small claims for claims below 1 million. The other day we had a case for a claim from a loan app for 4K. And the funniest thing is the claim itself is more expensive than the money owed, but that's not a big deal. You can do it yourself. So the small claims is available to you. Run like you're being chased because you're going to be locked out. Send them a demand letter. A demand letter is something you can just go to an advocate and get right now. We draft for you. Pay this money within this day or we're going to go to court. That's a demand letter. That is a way you can prompt someone to do something quickly, because a lot of people don't want to go to court. I'll just be honest with you. The demand letter is enough for some people. So what you can do is write a demand letter. Have a lawyer write your demand letter as well. So that way you can prompt this person. If they don't pay, go to small claims. Small claims will act for you. And here's the thing. Let me tell you about limitation of actions. For the following actions, this is the frame of time you should do a case before you're closing yourself. You're shutting the door to the courts. Number one, contract is 6 years. So if you had a contract and there was breach and something happened, and you've been sitting on it from before 2019, the door might be closed. You need to be running to court. Number 2, taught. Taught is like, how do I explain taught? Taught is like, to say you are doing something for someone and then something happened, an accident, and you need to file a case. You go file a case within 3 years, okay? This is general tort. Tort is like a mistake somebody has done to you, right? And then the next one is for libel and slander. This is like someone is talking crap about you and has ruined your reputation. It has only 12 months, you see? And then there's recovery of land, 12 years, like I said, unless for exceptional circumstances where like fraud is involved. And then actions against the government, depending, so it could be one year or 3 years, okay? And then actions on a judgment, so 12 years from the judgment date. So you see, it's been 3 years since you got a judgment and you're still sitting on it. Please, guys, be quick about your rights. Be quick about them. And then here's another question: are you a beneficiary if you are adopted by the wife of the deceased? Yes, if you are formally okay. Number 1, there are 2 differences between adoption. There's the formal adoption, which happens in court. We've done those adoptions. You go to court and a judge is there and is asking the kid. You realize that this person is now your parent, and if that person the child had a parent, saying you're renouncing this parent is no longer your parent, declare that this is your parent, you understand that this is your parent. It's a whole thing. You do adoption in court, it's a whole thing. Unless the child is below a certain age. So you have a court order, that one you've been adopted. You can inherit from her estate, even the husband's estate. You are a child. An adopted child is as good as a biological child. Now, informal adoptions are different because you have to prove that you are being taken care of as a child, which is as simple as producing like school fees payment, receipts, things like that. Prove that you are being provided for by this person. And it's not as obvious as if you were like a biological child. You're like those uncles now. You need to prove that you are dependent and you are being those provision for you. Okay, so you can indeed be a beneficiary and inherit from the deceased estate if you're an adopted child. But if you're informally adopted, please bring proof. Okay. Let me see. What's the next question? What is the next question? Oh yeah, and if you guys have any questions about succession, just put them in the chat so that I see, so that we can answer them as we go along. Or any questions about custody or like being a beneficiary in succession. Can somebody explain in the comments what it means to co-host? Because I've had like 7 people asking to co-host. What are they trying to do? Please comment what that means. Oh, then kuna huyu ati the mpango wa kando has a fraudulent marriage certificate. She can be arrested, okay? That's the end of story. She can be arrested. That's not something to scare you, okay? Or like, what do you mean a fraudulent marriage certificate? Like, where do you even get that? So I need to understand the situation. Like, what is she doing with it? Like, what does she want to do with the fraudulent marriage certificate? Number 1, report her to the police. That's serious, okay? The next question is, a landlord refused to refund the deposit. What can you do? Go to court. Okay, no. The easiest way is send a demand letter. Okay, and I also need to see the tenancy agreement, because some of you guys, you're staying in plots and kwa nyumba, and then you don't even know like the terms of that agreement. Okay, so I'd need to see the tenancy agreement, because maybe I've read one tenancy agreement. Okay, let me tell you what this guy did. He signed a tenancy agreement where the landlord had stated very clearly in that agreement that if you leave the house, you have to do renovations. Okay, and if you don't do the renovations, the deposit will be used to cover the renovations. So this guy left that house, and the landlord, because he was bougie AF, he went and did renovations for over 100,000. So those renovations were like, I think about like 200K. Can you imagine? So, and his rent was like 50K, that guy. And his deposit was like 100K. So the landlord went to do the renovation and asked him to pay that money. And the guy's like, but you've already eaten my deposit. But then the landlord was like, no, there's an extra like 80K I've used for the renovations, and you agreed in the agreement, the tenancy agreement, that you would pay for all renovations after you moved out. So not only am I not giving you your deposit, I'm also asking you for like an extra 80K. And he took him to court, and the guy had to pay the money. It was really bizarre. But so you read that tenancy agreement, okay? Read the tenancy agreement. Who are these people? Please write in the comments. I don't understand what that means. So yeah, be careful of the agreements you're signing. And so, but if you didn't sign an agreement and you had like an informal tenancy, just go to a lawyer, discuss with that lawyer, and we can possibly write a demand letter to get that money back. And also, depending on what level of rent you are paying, you will either go to the rent restriction tribunal, which is like for, they say the rent is 2,500 and below, but think maybe like 10K up or 20K, you can go to rent restriction, and then they'll show you the way forward and ask for your deposit and send a demand letter to that person. Let me see. Oh, this is a question because of my video about civil jail. Okay, how long does a sentence in civil jail take? Civil jail is the most unique thing I've ever encountered in civil procedure. So here, basically, if I win a case against you and you don't have any money, any assets for which you can furnish that judgment, like you owed me money, you have no money, you have no need, anything, we can decide to send you to jail. And that means that when you're on it to civil jail, you're serving a sentence, and when you serve that sentence, it clears all your debts that you had because of that judgment. So it's 6 months in jail. Here's the thing. I guess the best part about civil jail is even if the money you owed was 100 million shillings, you've lost a case and it's 100 million shillings. If you If you go to civil jail, then the whole balance is cleared out. That's 6 months. Whether your debt was 5K or whether your debt was 200 million, you go to civil jail, live there for 6 months. And that's that. And then the rule is if the judgment is below 100 bob, can you imagine 100 bob? Civil jail is only for 6 weeks. So you can go stay there next, you owe 50 bob. Like, some laws are really ridiculous. But anyway, so civil jail is 6 months. You just know that it's 6 months to stay in civil jail, and then your debt is cleared. Now the problem is you might not be in a position to go to jail, and it's jail. It's not like some fancy jail. It's jail, okay? You might not be in a position to go to jail, so you need to furnish that judgment. So that's why we say defend yourself. Even if to some you don't have that money, you can actually petition the court and say, hey, can I pay in installments? Hey, like, I have a family, I can't go to jail. Hey, you know, people just sit on their rights, and that's why it ends up blowing up in their faces, because they didn't even go like in person. I've seen people go to plead in person and be like, hey judge, please don't send me to jail. Listen, I'll pay that money, I'll pay it. So before you are committed to civil jail, there's an application like a notice to show cause. You're served that application and told, go to court and tell the court why you should not be put in jail. And people don't show up, and then there's a warrant of the arrest, and that's when they start panicking. Like, it's crazy. Any questions about civil jail, you can put them in the comment section, or any judgments. None of the messages. Where are the messages going? Interact. Is this where it is? No. Where are the messages going? Okay, let's just continue with the questions. We are almost at the end of this live. I need to get through all these questions. Okay. Now we're just gonna be rapid fire answers, okay? So the father passed away and the step family has leased out the land without consent. They're intermeddling. Go to court quickly. Get them off the land, okay? The intermeddlers. You can immediately stop them. And then the next one is, what if they fire you after probation? Depends on your contract, but if you're fired, you're fired. Okay, you can, if they've not paid you your salary, then you can indeed take them to pay you that salary, but not for unfair. So I think don't get me mistaken. If you're on a probationary contract and they've not paid you your money, you can get your money. Okay, that's fine. But if there are any other benefits, unfair termination, you can get damages. You can get like 6 months salary because they terminated you unfairly. So not only do they have to pay you what they owed you, but even 6 months of salary for when you're going to be looking for a job or whatever. But for probationary, you can't do that. They'll just pay what they owe you. So you can go to court, right? If it was an unfair thing and they've not paid you your dues and they've not followed the contract, you can go to court, definitely. And also there's something called the labor office. They can also help you also. The next question is, what does a person need to have for registering a property interest in marriage? This question was kind of odd, but let me explain to you something. Okay, so when people get married, there's something called matrimonial property. Okay, number one, you can have a prenuptial agreement. Yes, it exists in Kenya, where you say that any property I get will be mine, any property you get will be yours. Or you can say something like, the property I got before marriage is mine, which is true, and the property you get during the marriage, you can agree to that before you get married. Most people don't. So next is this. When you're getting a divorce, number one, the children will be dealt in their own courts. The divorce will be in its own place, and matrimonial property will be another case. So, get the divorce, you're just splitting you, nothing else. No children, no nothing. We're just splitting, okay? That's it. Then after that, you go to matrimonial property. If you guys got property together during the pendency of the marriage, that is considered matrimonial property. And you have to see the contributions everybody did to the property. It's something that the court will determine, or you guys can agree during the court case, okay? So if matrimonial property is property that you got during the pendency of the marriage, let me even read to you. Where is this? Anyway, I don't have it open, but tuseme you guys bought a house and you lived in it. That is definitely a matrimonial property. The house you lived in together during the marriage is your matrimonial property. If you buy a property in your name, it could still be matrimonial property because contribution doesn't have to be money. If this person, built the walls, or, I don't know, whatever contribution they'll consider, it can be considered contribution. That's why you'll find that if a person is married and they're selling property and they got that property during that marriage, there has to be a spousal consent. Okay? You can't just sell that property without telling your wife or without telling your husband if it is matrimonial property. So know that when you acquire property during your marriage, it's considered matrimonial property. Okay, good. But anything before that, not really. Another thing is, you need a court order. Somebody asked if the wife is refusing in the house. I'm sorry. If the wife is or somebody is refusing in the house, you're divorced, but you have to go to matrimonial property. And to evict a spouse from the house, you need a court order, okay, or a former spouse or whatever. So to evict somebody from the matrimonial house, you need a court order. So either you leave or they leave. If it's a rented, whoever's paying rent, I'd have to know those facts, okay? And the next question is, oh my gosh, I only have 3 minutes left. This person was not included in succession, and they're denying her as a sibling, and the succession is for the mother's property. Number one, all children are beneficiaries. Whether you were born out there or born from where, as long as you prove your biological child, you're a beneficiary. So those children who are like, I'm illegitimate, wait for your turn. Everybody has a right to inherit, okay? Male or female, even if the deceased says, oh, the boys are going to get this, the girls are going to... If a girl is disinherited, she can go to court, okay? Because Article 53 is about children. All children are equal, so all children have the right to inherit. Now, you need to prove evidence, right? So actually they're saying they're not your sibling, please. That yapping, do they have any evidence, okay? If you have evidence of your birth certificate, marriage certificates, any other records to demonstrate a relationship with this person, bring them. And at the end of the day, these days, DNA is there, so they can't just yap, just say, I'm willing to take a DNA test, I know this person is my parent, okay? Next is, don't sleep on your right. Now, here's the problem. People will wait until succession has happened, you've already been disinherited. Yes, you can get some property, but listen, things would already have moved, so it will be more costly on your part to reopen that case. you're like shifting everything. By the time you've come, they've sold everything, and so now we're trying to get like money from these people to compensate you. So go quickly. Remember that all children are beneficiaries. All children have rights to the parent's estate, and male or female, they can inherit. I know it's complex because of our cultures and everything, and others just they give the boys and they don't give the girls, but according to the law, everybody has the right to inherit. And then finally, the last question: beneficiaries have been intermeddling and can the grandchildren go to court? Definitely 100%. Anybody who's intermeddling. But listen, you need a grant ad litem. So what you'll do is apply for a special limited grant to litigate. Okay, you need locus standi. Locus standi means you have a right to be in court. Like you're not just any Tom, Dick, and Harry starting a case for. Like I can't start a case for my neighbor. Like who am I to my neighbor? What do I have to do with that case, right? So you need to prove that you are the right party to be initiating this case. So do a grant ad litem, which means it's a grant to allow you to file a case on behalf of an estate. And then make an application to cease and desist. What's going on? Oh, okay. Oh gosh, what's going on? Okay, so anyway, that was the last question. There's something weird going on with this live, but if you have any more questions, I hope I answered them. You guys are really quiet in the comment section, so that's all. If you have any questions, put them in the chat right now. I'll answer them in like a minute if I can. If you have any questions about succession, please leave them in the comment section. Thank you for everybody who joined. I'll be posting more videos like this, but yeah, the number one thing I want you to take from this live is don't sleep on your rights and run to court or to a lawyer or to a kituo cha sheria or something that will help you, because there are very, very many places that offer free legal services to people who don't have the means. It's very, very possible. So yeah, I hope you enjoyed the live. We'll do another one another time. I really enjoyed it. See you in the next one, because I'm not seeing any questions. See you in the next one. Bye, guys. How do you stop this? End live. So I'm ending. Bye, guys. See you.